Good afternoon. Today, Eastern European Dispute Resolution Forum presents quick and honest interview with Adrian Lifely, partner in Osborne Clarke Dispute and Risk Practice based in London. My name is Olena Perepelynska. I'm partner in Integrites and one of the members of the organizing committee of the Eastern European Dispute Resolution Forum. So the topic of today's interview is London is the capital of arbitration, and we will discuss how to persuade a UK tribunal about your case. So, Adrian, before we move to our main topic, could you please tell us about your background and experience in arbitration?
Thanks, Olena. Yes, hello everyone. It's a real pleasure to speak to you in this conference. I'm an English solicitor, so I'm qualified in English law, of course. As you've just heard, I practice in London. I've been practicing in the area of commercial disputes, doing arbitration and litigation for 30 years. I was actually one of the first lawyers in London to get involved in CIS disputes. That was way back in 2005. And I've been involved in CIS disputes ever since, as well as other kinds of cases as well. Next month is an exciting time for me because I will leave Osborne Clarke after 25 years as a partner, and I will set up my own practice as independent arbitrator and mediator, something I'm looking forward to hugely. The types of cases I've done over the years are really varied. So if you look at it from a sector point of view, I've covered technology, finance and banking, real estate, construction, IT, all sorts of areas. What is a common thread, I guess, with all my work is they involve commercial disputes. And sometimes that's a contract dispute, sometimes it's a JV dispute, a shareholder dispute, sometimes it's fraud. So many cases. I've been lucky enough to do cases around the world, in the UK, of course, but also in Europe, the US, Middle East, and Asia. That's it. Thank you.
Thank you very much. That's really interesting. Adrian, the jobs of the counsel and arbitrator are obviously different, but what kind of different challenges do they have? How do you think?
You're 100% right. There are overlaps, of course, but essentially the roles are different. Counsel wants to win the case, and the arbitrator wants there to be a fair and efficient process for deciding the case. I would say that characteristics of good counsel, you need to be passionate, you need to be somewhat partisan, but realistic, of course, and as arbitrator, on the other hand, I think you need to be calm, you need to be patient, and you need to be open. I think that's really important. You need to be open to new ideas, new ways of thinking, and new arguments. As an arbitrator, what makes a good arbitrator? I would say a good arbitrator needs to really understand the case. Obviously, that means the law, that goes without saying, but more than that, needs to really understand the parties and their situation. If the arbitrator does that, then he is likely to deliver a correct decision, which the parties will understand and they will accept. And that, of course, is good for arbitration.
Is there any difference between arbitrating in the UK and elsewhere?
Yes and no. I know that's a lawyer's answer, but it is actually true in this case. It's a bit different. There are important points to bear in mind if you come to do a case in the UK. The first thing I would like to mention is about credibility. It's really important that you as counsel have good credibility in the eyes of the arbitral tribunal. It's really important that your witnesses come across as credible and believable, so much so that if you don't have this credibility, you're at serious risk of not succeeding with your case. The other thing to bear in mind is that the English are fond of oral evidence. There's a long tradition through the court system of deciding cases without written evidence at all, only on oral evidence. That, of course, has changed, but you need to imagine that to understand how important oral evidence still is today. So when you're preparing your witness statements and you're preparing witnesses to give evidence before the arbitral tribunal in the UK, do bear that in mind. The cross-examination is very important and can decide the case one way or another. You can lose a case if cross-examination does not go well. Other things I would mention just briefly is that UK tribunals are not frightened to find fraud. I contrast that with some civil law tribunals I have been in front of, where they seem out of tradition very reluctant to decide there has been any fraud and will look for any other reason for deciding the case except for fraud. Foreign law is another point. In the UK, we have a long tradition of hearing cases from overseas, and therefore we're quite used to deciding cases based on foreign law. We're quite comfortable with foreign law. Lastly, in the UK, the tribunal will be quite passive. Will let counsel run the case like counsel wants to run the case. Now, that is good in terms of the freedom it gives you as counsel, but it can be not so good if you're not 100% in control of your case, because the tribunal will not help you out so much. The tribunal will not ask helpful questions of opposing witnesses, for example, because the tribunal will expect you to do all of the work. So you need to be really well prepared if you arbitrate in the UK.
So I think one of the most important and interesting question is how to persuade the arbitral tribunal about your case.
I thought you would ask me that question. So it goes back to something I said a moment ago. You have to be credible. The tribunal needs to be able to trust you as a reliable guide through the case, a way of really understanding the case. I compare it with football. So imagine in football, you have a captain for each team and you have a referee, of course. The relationship that the captain has with the referee is rather special, and it can be very important. And the captain, from the very start of the match to the end of the match, will be trying to build a relationship of trust with the referee. And he'll be doing that for those key moments when there's a big decision that the referee has to take about the game, for example, whether to award a penalty. And if the captain has done his job really well and built this trust with the referee will listen to the captain when he makes some comments, when he makes some arguments about that decision. The result, of course, is that there is more chance of the captain having some influence on the outcome in a positive way if he has this relationship. So back to arbitration. I think it's important that the arbitrators follow the arguments that counsel is making without any distractions, without any concerns about whether the counsel is reliable. And if that happens, then you have a better chance of winning. So the way to build that trust is to come across as reasonable, to come across as someone you can trust. Don't make extravagant claims. Stick to your main arguments, which are good arguments. Don't make any arguments that do not pass the red face test. It's embarrassing, it destroys your credibility, and there is no point because the tribunal will see through it. So all the time, think about your relationship with the tribunal and build on it like the captain of the football team.
Thank you. This is really interesting and helpful. But if we look at this relationship with the arbitral tribunal in another way. And so if you could give some advice to our audience, so what helps or what irritates the arbitral tribunal?
Well, I'm not easily irritated, but as regards what helps, I think clarity is really important. You need to make your case really clear to the tribunal. Tell the tribunal from the start of the case what it is you are going to prove and why it means you will win the case, and then guide the tribunal through each stage of establishing that line of logic to why you win the case. What's quite unhelpful to tribunals is very long pleadings, very long memorials, excessively long, I mean. Guerrilla tactics, of course, are really unwelcome, and of course they're designed actually to disrupt the process. So of course they will be difficult for tribunals. Changing one's case midway through the case, or even towards the end of the case, is really unhelpful, as is late applications for disclosure of documents. So I think put yourself in the shoes. It's a bit like talking to a client. If you're talking to a client, you have to think, well, what's their level of understanding? What's their personality? And depending on that, you may present your advice in a different way so that it's receptive by the client. So it's a bit like that with the tribunal. You put yourself in their shoes. They want everything clear. They want the case authorities and the evidence to be easy to find. You don't want to spend time looking for documents. You want to spend time thinking about your case. Then you have a better chance of winning the case. So put yourself in the shoes of the arbitrators, just like you routinely, I'm sure, put yourself in the shoes of your individual clients. And then I think you will get it right.
Thank you. Is there any difference between barristers and solicitors as arbitrators?
Yes, this is an interesting question, and I always get asked this because I think foreign lawyers have a fascination with this difference, because we have this what's called a split profession. We have solicitors and we have barristers. In the international arbitration world, there's sometimes not much difference. If you have a barrister who has been doing international arbitration all of their career, just like a solicitor who's been doing international arbitration all of their career, they will be quite similar. But the real difference comes where you have barristers who have spent most of their career doing court litigation as opposed to arbitration. For barristers like that, this is where you sometimes come across an extremely formal approach. You might say they come across as very British. So you would get that. In terms of the way they do the case or their expectations of the way counsel will do the case if they're arbitrators, they may be more tolerant of aggressive and long cross-examination, because that's the court tradition in the UK. Also, they might be more wedded to black letter law and less willing to look beyond a contract at what the circumstances of the case are, the background of the parties, and so on. The other thing I would say is that solicitors they are the ones who deal with clients on a daily basis, not the barristers. So solicitors like myself tend to be more in tune with what it's like being a client, what it's like for your clients, for the parties. Whereas barristers get involved only where there is a dispute, and at the end of the disputes, they don't have so much client contact, and maybe they don't have such an appreciation of the circumstances that the clients find themselves in sometimes.
So Adrian, as you have experience in both English and civil law style of conduct of arbitral proceedings and drafting respective submissions in arbitration, so what are the major pros and cons of each style?
Well, this is the way I see it. International arbitration proceeding, you know, the the pleadings, the witness statements, the experts' reports, the disclosure of documents, and then the oral hearing. That process is quite similar to English court litigation, and it's quite different from civil processes where there is less reliance on a hearing and more reliance on documentary evidence. So that was the starting point of international arbitration procedure, as I see it, broadly based on the English litigation. But that has changed. In the course of my 30 years of practicing, I've seen that change and move, I suppose, more towards the civil law tradition, so that we end up kind of midway between the two traditions. And I say that because we now have, quite often we now have memorials where pleadings are served alongside obviously the evidence. And we have limited disclosure, and we have this preference for documentary evidence over oral evidence. And that, I think, is in the process of being really accepted in the UK as well as in civil law countries. So I'm doing a couple of cases at the moment where I'm sitting as arbitrator in London in LCIE cases. And we have a memorial system. We don't have a pleadings followed by separate exchanges of witness evidence. And actually, I like that. And I think we're ending up in a really good place. I like it because I think documentary evidence is really important. I like it also because by having written memorials served at the same time as the evidence is a really good discipline for the lawyers, because you can't make claims in your pleadings which are not supported by the evidence, because it would be obvious that the evidence is not provided because it all goes in one document. So I quite like that, and I think it leads to a quicker identification of the issues and the strength of the cases based on the evidence. But that's where we are as I see it. If you were to look back in 25 years, I would say that at the moment we are not quite there, but we are transitioning to a point where there is less and less difference between these common law and civil law traditions, which, as I say, I see as a really positive thing.
My next question is a bit different, or goes in a bit different direction, and it's about importance of relations. I've heard about your initiative, International Arbitration Supper Club. So could you tell us about both these issues?
Certainly. Well, I think people make the world go round, and that's certainly true in the case of international arbitration, where it's very important to know people and to respect people. That's how we decide cases efficiently, and it's how we gather knowledge about international arbitration, which is also very important. So in 2014, I established a network in London called International Arbitration Supper Club. There's a website, IASC website. And we wanted to do this in order to promote social interaction between practitioners in London. There were, as I saw it, there were lots of occasions at conferences where you could discuss international arbitration law, but there weren't so many situations where you could discuss the business of practicing international arbitration. So I set up the Supper Club, and we have a dinner 3 or 4 times a year. A different law firm hosts it each time. And we have about 20, 30 people having the dinner and having a discussion led by a speaker, and then a debate afterwards. It's all under the Chatham House rule, and it's really good fun. And it's also really useful in building those relationships and increasing our knowledge about the business of practicing arbitration. I'm pleased to say that it's going really well. We've had to stop temporarily, of course, because of the pandemic, but we're ready to restart as soon as lockdown ends. And we have, I think, 5 dinners lined up for London and several in Moscow, because we started in Moscow 2 years ago. And last year we started in New York as well. We had our first IASC dinner in New York in February, and we will have another one hopefully later this year. And we will also hopefully go to Dubai this year and have our first dinner there.
In my practice, I have seen quite aggressive counsel at some London-seated arbitration. Could you tell our audience about the origin of this style and how it is perceived by the arbitral tribunal?
Certainly. Well, in my opinion, being aggressive is not necessary. And it can be a distraction because the tribunal ends up having to react to your aggression rather than thinking about your case unhindered by those kinds of distractions. So I would say to counsel, if you can, try to be calm in the way you present your case and in the way you cross-examine witnesses. And in relation to cross-examination in particular, I've seen situations where being aggressive towards a witness, which, as I say, I don't think is necessary or produces good results, I've seen it actually produce bad results in the sense that members of the tribunal have felt the need to be protective of that witness. And they have focused their attention on trying to make counsel be reasonable and respectful to the witness rather than thinking about the fact that the witness is maybe not telling the whole truth. And that's quite a serious situation if you find yourself with that happening. I mean, in terms of your question about the origins of this kind of behavior, it goes back to court litigation, where, as I said, all of the evidence was oral many years ago in the UK. And witnesses did not have a witness statement. They turned up at court without any previous discussion with either side's counsel, and they were questioned about the case. So everything hinged on the evidence of the witnesses. It was absolutely vital. And this approach of being aggressive in order to try and get a witness to agree with your case emerged. And I think counsel who felt they were going to lose the case anyway, felt they had nothing to lose and therefore would try and break down the witness. You hear this phrase, breaking down the witness. But, you know, honestly, in my 30-year career, I have not seen that happen very many times. Usually what happens is the witness stays calm and just denies everything that is alleged by shouting counsel. And it actually ends up not really getting very far. But that's how it all comes about, Olena.
Another interesting topic is application for foreign law in arbitration and use of experts. Sometimes both parties' counsel are qualified in applicable law, but still decide to use expert in that law. I'm particularly interested in your views on that point, and especially if one of the members of the tribunal is qualified in that applicable law. So how the arbitral tribunal would treat all these issues?
Yeah, I think it depends on how important the foreign law issue is. If it's a case that will determine the case one way or the other, then one has to consider that each member of the tribunal has an individual responsibility for making up their mind about the case, and that includes about foreign law. So in some way, the tribunal member who is not qualified in that foreign law needs to get their head around the foreign law issue, and either they do that by trusting the co-arbitrator who is qualified in that law, or they obtain expert evidence. Actually, what nearly always happens in English cases is the decision, do I ask for an expert opinion or do I rely on counsel, is taken out of the hands of the tribunal, because parties to English arbitration will, in my experience, pretty much always instruct an expert, a foreign law expert. So what you are doing is, on the tribunal side, is whether you're qualified in that law or not, is you have to decide, based on the expert evidence that you've heard from each party, what the answer is as regards the foreign law question. And this is something that has always been done in the UK because, and I mentioned this at the beginning of our discussion, for hundreds of years, the UK has been a centre for international disputes, and therefore foreign law has always been an element of doing disputes work in the UK, and it's something that English qualified disputes lawyers are quite comfortable with. So I think at the end of the day, you don't get those situations of imbalance that I think your question underlies your question, where one party is disadvantaged because they don't have a foreign qualified lawyer on the panel and the other party does. Because at the end of the day, I think it's expert testimony on that foreign law that will decide the point.
Thank you for interesting discussion. In the end of our interview, I would like to ask you several brief questions, and I expect to receive very brief and fast answers. So, what do you like most of all in arbitration?
I like that it's multicultural.
Okay, if you need to explain the advantages of arbitration over litigation in 3 words, what would you say?
Over litigation, it's flexible, it's fair, and it's inclusive.
Thank you. So what would you recommend to young lawyers wishing to become arbitrators?
Become really excellent counsel first.
Okay. What kind of skills should the arbitrators develop in changing world?
I think understanding is what is key, and I think you need patience. I think you need to listen. Lawyers are not very good at listening because they love the sound of their own voices, and so they like talking and stops them listening. And I think you need some kind of independence. You need to think for yourself. You can't just rely on the presiding arbitrator. You can't rely on another arbitrator where there's an aspect of foreign law, as we discussed earlier. So I think you need to think for yourself.
Okay. Have you ever had a sleeping arbitrator or a judge in the proceedings, and what have you done?
Yes, of course I have. And it was after lunch. It was in Europe, and I dropped my file on the desk quite loudly. And that
Did it help?
Well, the arbitrator woke up, but I think he was still rather dozy.
Okay. So, if not in arbitration, what would you choose to do professionally?
I would like to be a psychiatrist.
Oh, that's interesting. Will you continue developing your initiative of the supper club in post-COVID times?
Yeah, we want to conquer the world, of course. And I think next stop is Dubai, I hope, in the Middle East.
So what is your favorite book, and what is your last or current book?
So I have been busy, because obviously we're in lockdown, I've been busy reading travel guides because I'm looking forward to traveling. So I've been reading about Portugal this week and trying to decide where to go as and when we're allowed to.
Do you think arbitrators could be replaced by artificial intelligence in 10 years perspective?
No way. We're far too intelligent for that.
Do you think Brexit has or would have any negative effect for choosing London as a seat of arbitration?
No, there's no reason.
And last, what was your worst moments in arbitration?
So yes, my worst moments was in a case in Switzerland, and I was acting as counsel on that case. And our main witness, who didn't speak English and arrived late for the hearing and had been in hospital for 2 weeks before that and wasn't very well. There was one key question in the case for our key witness, and it was, did you sign this agreement? And the answer was supposed to be yes, and he answered no. And I asked the question again, and he answered no again. And then we took a short adjournment.
Okay, that's not easy, really.
Nightmare.
Yeah, so Adrian, thank you very much for this interesting discussion and for the answers provided. I hope our audience now know how to win a case before the UK tribunal. So thank you and have a good day.
You're welcome. Thank you very much.
Thank you.